the scope and applicability of corroboration. We have explained the meaning of the word corroboration and the rules guiding it. So what next is to look at the scope, which actually they have done. And in scope, you're looking at both the statutory scope and the practice. Statutory scope and the practice. Remember that I told you that the Evidence Act does not require the evidence of an accomplice to be what to be corroborated. So, but what it has done here is to give the judge the discretion. The judge, you may require it, but if you don't get it, it doesn't mean you can't convict based on evidence of an accomplice. So long as you do what? You warn yourself. So long as you warn yourself. So that's one of the things we have to look at there. So this one coming under the statutory provision. And then the next thing is Section 197. Section 197 provides for corroboration in actions for breach of marriage. Actions for breach of marriage, talking of the scope. And it says, no plaintiff in any action for breach of promise of marriage shall be entitled to succeed unless his or her testimony is corroborated by some other material evidence in support of such promise, and the fact that the defendant did not answer letters affirming that he had promised to marry the plaintiff is not such corroboration. So I will tell you why. I will divide this provision into two and tell you why the latter provision is the way it is. Now, this place is not talking about that any relationship must, translate to marriage. No. But it's talking about if for any reason one has promised to marry the other, whether the female promising to marry the man or the man promising to marry the female, once there is a breach of such promise of marriage, the victim can sue, but the victim evidence can alone will not do or sustain the claim. He must have what? Corroborative evidence. And at times you want to ask me, why would the law require corroboration in a breach of promise of marriage, given the fact that it's not everybody, or let me say every man that is rascal enough to go and kneel down before a girl and then you want to propose to her? That's rascality. And it's not everybody that does it. And some of the times, promise to marry cannot always be what? Be secret. Just between two of them. Right. Why would we talk about corroboration? Knowing fully well that in some of the material given facts, when the person has promised, there is no person that was present. At times you watch some of these skippers, what do you call it, Sonia official. And they said somebody was training a girl, and then as at the time he came back, he wanted to propose to the girl, and the girl said, no, I will not marry you. And the guy gets angry, I will do this, I will blah, 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 blah. Why? Why would you get angry? Before lavishing your money, that proposal should have come first. But you have already lavished the money and you have come to propose. She's not bound to accept. Why? Because that is just an offer. It's not every offer that will be accepted. All right. But for ladies too, it is unconscionable. If you will not marry him, don't let him go too far. There was one somebody sold his mother's land to buy a phone for a girl. Why? Because he said he's going to marry her, but which law? So you look at instances like that. So this law is careful not to capture those rascal acts. It simply it starts from where the promise has been made. And do what? Accepted. Marriage is what? Contract. Elements of contract, offer and acceptance was the other ones. But the basic ones, offer and acceptance. And what actually happened was that there was this promise of marriage. She accepted. So what the man came back from overseas to do now is to set a time frame for the marriage, and the lady refused. That one is actionable. And then another one, a trader in Idumota was training this girl. She went to university, and as far as he's concerned, even though he's an illiterate, that lady's certificate will cover the whole of them. That one almost made me cry. But the girl had the gut to tell him, "You're not my class." Which class? When he picked you. So once there is promise and there is the offer and acceptance, there is what? There is a contract. So if the man says no or the lady says no, there is what? Breach of promise to marry. And then the second arm here says, try to exclude the fact that one of them has been writing letters to the other person and the other person is not replying. Should not be the corroboration required. Shouldn't be the corroboration. Because when you look at series of English cases, it was a corroboration. Maybe two persons have agreed to marry, and the other one is writing, I'm counting down 14 months, and they was, oh, no problem, we are getting ready, and then they write another one, the same thing, and they exchange it, and then when the man comes to say, okay, let's go shopping, let's find what and what you need for the wedding, and the lady says that she's not ready, that she wasn't going to marry. So under a lot of decided English cases, those letters amounted to what? Corroboration. But this place is saying what? No. Why? Why will our own be different? So that's why one thing I'm looking at this very provision, find out if you have any justification. If you think there is justification behind the enactment of this second arm of the provision.
Because we don't write letters.
Who told you we don't write letters? Do you want us to check phones?
We don't write letters.
No, we do. Even when you send text message, what are you doing? You're writing letters. Why? Before phone came now, it was letter writing and all that, All right, so that is it. Here, there has to be a complete contract. The problem is, what if, as at the time the contract was arrived at, concretized, there is no witness? How do we find corroboration? For the second arm of this law, to exclude letters also means that there are some acts that can also mean what? Corroboration. Let's say, for instance, the man shows wedding gown. She accepted and I bought wedding gown. The girl said, where you are lying. And the man said, look at the wedding gown, look at the wedding ring. If you were a judge, what will come to your mind? That this man would not have been stupid enough to go to the market to buy wedding gown, when there is no such agreement, which means the man's evidence can be corroborated by an overt act, but so long as it is not letter writing. Even it could be maybe the girl has told her friends, this is how it's going to be, this is how it's going to be. Especially when some girls get to final year, they will start posting, hey, my marriage, blah, blah, blah. But in the end, after 2 years, I see, no, it has not happened. So look at 198. Okay, I've explained 198, the evidence of accomplice. It can have corroboration, but it's not required as a matter of course. It's not a statutory requirement. And then the 200 is the statement of the general rule that generally one witness can do what? Can establish your case. But in some certain circumstances, you must look for what? Corroboration. Like we have looked at 197, and then the next one now is 201, treason and treasonable felony. These are serious capital offenses. So I just run down. A person charged with treason or with any of the felonies mentioned in sections 44, the 142 of the Criminal Code Act cannot be convicted except on his plea of guilty or on the evidence in open court of two witnesses, at least to one overt or the kind of felony or like. Now, in treason, the only time you can convict the defendant is when he has done what? Confessed. That's when you can convict him on the evidence of one witness. But apart from that, when he said, I'm not guilty. He pleads not guilty. Then you're looking for two witnesses. Each of the witnesses must do what? Give evidence pertaining to one of the overt acts leading to what? Treason. If two of them come to say the same thing, come to prove only one element, then the offense is not what? It's not proven. So that's what this place is saying now. Why? Because it is a very serious offense. Except, of course, if in the pursuit of the plan to consummate that offense, the president is killed or endangered, like subjected to a bodily harm, that is when we can say you may not require corroboration. Why? Because that is the very act. And then perjury. Perjury is an act of giving evidence on oath, but telling what? Lies. Lying on oath. Why would this require corroboration? Why? You say it cannot be proven to be a lie unless there is evidence to show that it's a lie. Why? Because evidence given on oath is regarded as what? A sanctimonious evidence. It's a solemn evidence. Do you understand? So, and the person has sworn that I'm telling the truth and nothing but truth, so help me God. What is the meaning of so help me God? So deal with me anyhow, God, if I'm lying. That's the, but they don't understand. That's the meaning. I've already said I'm saying the truth. So if you know I'm not saying the truth, it's for you to do what? To give evidence to show that I have not spoken the truth. Now, how can, assuming A has spoken on oath, and I want to challenge him to say he is lying, which, when I say he is lying, how do I satisfy this condition of corroboration? How do I satisfy it? My evidence is one, right? My evidence to say he's lying is one. Where is the corroboration? Either I have a documentary evidence to traverse what he's saying, or to use what? That affidavit he has sworn, or that statement he made on oath can also do what? Corroborate my evidence. Do you understand? If, for instance, maybe somebody said, I did something here, and then on so day, I was so place, I did this, I did, and I just came to say, no, I was with this man on that very day. Look at our picture. Look at our conversation. What have I done? I have given evidence and I have supported it with what? Documentary evidence, which is what? Corroborative evidence. So that's one of the ways of challenging that. And then the next one here, exceeding speed limit, we have talked about this quite often. When somebody is exceeding speed limit, it requires corroboration, except you are caught by what? An officer of the law in charge of that traffic officer. And then I also asked, why would the fact that an officer has caught me be a corroboration, or will not require corroboration? And at times, if I was caught and then light was checked, and then from the time it was discovered that I ran a red light, a person charged under any road traffic legislation or driving at a speed higher than the allowed maximum shall not be convicted solely on the evidence of one witness that in the opinion of the witness was driving at a high speed, provided that it requires corroboration, but provided that the evidence of a duly authorized officer of the relevant authority who was at the time of the commission of the offense operating any mechanical. So the corroborative evidence here is what? Mechanical gadget, electronic gadget, or any other device. So if the man doesn't have any of such device, his evidence cannot be said to have been corroborated. And then this before the last, sedition. A person shall not be convicted of the offense of uttering seditious words under section 51 sub blah, 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 upon the uncorroborated testimony of the witness. You know what sedition is? Anything that is capable of creating that kind of desire in your heart to break out from the Federation of Nigeria or to cause problem. So just like some groups have been doing or did in the past. For you to prove that, the prosecution needs what? Corroborative evidence. Finally, So section 209, we talk about unsworn evidence of a child. Where a child gives an unsworn evidence, that's a child that is below 14 years, and he gives an unsworn evidence. That evidence must be what? Corroborated. So if there is no way you can corroborate that evidence, it means that that evidence does what? Goes to naught. So thank you. We'll find time to meet again. Have a nice day.